So we're now looking at things that are defined as not being hearsay. These are things that otherwise absolutely meet the definition of hearsay under 801C, but 801D simply says they're not hearsay at all. We're going to get into later rules 803 and 804, which define things as exceptions to hearsay. Practically, those things operate the same way as 801D, which says that these things are simply not hearsay. When you look at them, you really won't see a great deal of difference between them in terms of why the label might matter. For those who are very precise, and there are certainly judges out there who are very precise, they give you a lot more credibility if you say, objection, Your Honor, this is not hearsay under 801D, as opposed to saying, objection, Your Honor, this is an exception under 801D. It's an exception if it's under 803 or 804. It's not hearsay if it's 801D. I don't personally care. I think these labels are very arbitrary. I don't see any meaningful reason that some are called exceptions and some are called not hearsay. But knowing that, that's a little credibility boost that you can get with a judge if you know that meaningless distinction, because that's how the rules describe them. So let's get into the actual rule and look at 801D, which I've provided for you on Charter Course, which we'll now look at in that format. So if you look at 801D, we start with D1, and these are about statements that a person who's now on the stand previously made. So if 801D1, a declarant witnesses prior statement. So if the declarant is now on the stand and subject to cross-examination about not only what he or she is currently saying, but what he or she previously said, which just means the person's testifying and is capable of responding to questions, not a really high threshold. So the person's now testifying on the stand, and you're looking at their prior statement. So D1A, if the prior statement is inconsistent with the current statement, we'll get into what inconsistency means. If the prior statement is inconsistent with the current testimony, and the prior testimony was given under penalty of perjury at another trial, hearing, deposition, or similar proceeding, then it comes in. It comes in as substantive evidence. I want to flag that word for you. Substantive evidence. There are times when we can bring in the person's prior statement that was not under oath. It won't come in as substantive evidence, but we can bring it in to show that the person may not be telling the truth right now because they previously said something different. We'll get into later why we care if it comes in as substantive evidence or merely to impeach the person's testimony. But for right now, understand that 801D1A addresses only the prior inconsistent statement that was made under penalty of perjury at a trial, hearing, deposition, or other similar type of proceeding. 801D1B says that if the person is currently on the stand and has previously made a statement that is consistent with his or her current testimony, that can come in either to rebut an express or implied charge of recent fabrication, or that the person acted from a recent improper influence or motive in so testifying. So, if someone was given, if someone they said the car is red, 5 days later, the driver of the blue car says, I'll give you $1,000 to say the car was red that ran over you, and at trial you say it was red. If you had said it was red before you were bribed, then that's good evidence that the bribe didn't influence your testimony. So you can bring in the prior consistent statement to rebut a charge like that. The more confusing one is 801D, D1B2. This one that's now kind of in the middle of your screen. You can bring in the current witness's prior consistent statement to rehabilitate the credibility of the witness when it's attacked on another ground. No one really knows what this means yet. And there's a really good case from the Military Court of Appeals that lays out what's been going on in a lot of federal courts in the country on that particular issue. We'll get into that. This is a new and fairly confusing provision in the evidence code that we'll get to. 801D1C, when the person currently testifying has previously identified a person upon seeing him or her. What's that really mean? What does that kind of formal language mean? It means a police lineup or something similar to it. And the reason for that's fairly simple. We want, when the person testifies in court and they say, do you recognize the person who attacked you? Yes, it's the person in the orange jumpsuit next to his lawyer at counsel table. Juries may well discount that identification because it's so suggestive. Well, who else would it possibly be? So we allow the jury to hear as evidence the fact that there was a previous identification as part of a more fair method of identification, the 5-person lineup where the people in the lineup can't see the person making the identification. All right, so now we go to 801D2. The opposing party's statement. You may remember me talking about this particular type of exception to hearsay, or to get it right, non-hearsay under 801D. When we talked about the Alabama case where the defendant was arrested for homicide and he gave some statements that helped himself to the police, and he wanted to bring those statements in. The court says you can't bring those statements in because they're hearsay. And it's an out-of-court declaration by you. And unless you testify, these statements are your out-of-court statements. And so they're hearsay and inadmissible. And I mentioned at the time, this would be different if the prosecution had sought to bring the statements in against the defendant, that an opposing party can always bring in the statements that the party has made. So that's 801D2. The statement is offered against an opposing party and was made by the individual, the defendant arrested in the Alabama patrol car, in his individual or representative capacity. If his lawyer had made a statement, it would also come in. 801D2B is one that the party manifested that it adopted or believed to be true. So if I say, or someone says, Oliver robbed a bank, and I kind of nod my head, then you could offer that evidence against me that I had implicitly adopted the statement that someone said I robbed a bank. D2C was made by a person the party has authorized to make a subject on the matter, authorized to make a statement on the subject. So, the president has a spokesperson. Anything the president's spokesperson says would be admissible against the president. 801D2D was made by the party's agent or employee on a matter within the scope of that relationship and while it existed. C and D are very similar. The difference really between C and D, C applies to a lawyer or a spokesperson, someone who is empowered to actually make statements on behalf of the party. And D looks at something like, say, a truck driver who's not hired to speak, but hired to maintain the truck and drive the truck. So if the truck driver says, look, when I got in the truck this morning, the brakes weren't working, then that is a statement within the subject matter that this employee or agent would have responsibility over. And then finally, D2E, made by a party co-conspirator during and in furtherance of the conspiracy. 5 of us agree to rob the bank. One guy goes into the bank with a note, and he hands the note, and he says to the teller, your money or your life. Well, that statement is now going to be admissible against all of us. because that's a statement in furtherance of our conspiracy to rob the bank that yeah, that's a statement during the course of the conspiracy in furtherance of the conspiracy to rob the bank. Now, if one of the five folks goes home and tells his wife, "We robbed a bank today," that is a statement made by a co-conspirator, but it's not made in furtherance of the conspiracy. And so therefore it doesn't come in under 801 D2E. We'll get into all the details of these rules as we work through some cases. This is sort of an overview of this set of non-hearsay. And if you go back and look at it, rewind the tape, and look at any problems you have at this point, or go ahead and go forward to the examples themselves, so you can see better how these work. Whichever works better for you at this point, you'll need to get a handle on how these rules work that are, relatively complicated. The harder stuff really is what is hearsay and what is not under 801C. But D is one of the more complicated areas of evidence law, so you'll want to make sure you have a good handle on this.